Conclusion. America Through Nazi Eyes. On September 23, 1935, 8 days after the Führer's proclamation of the Nuremberg Laws at the Party Rally of Freedom, a delegation of 45 Nazi lawyers gathered on board the luxury ocean liner SS Europa, bound for the United States on a study trip organized by the Association of National Socialist German Jurists. The group was led by Dr. Ludwig Fischer, at the time a high official in the Nazi Office of Legal Affairs. 4 years later, Fischer would be named governor of the Warsaw District in Nazi-occupied Poland. There he would serve as the top functionary during the brutal roundup of hundreds of thousands of Polish Jews. The creation of the Warsaw Ghetto, in which, he promised, the Jews will croak from hunger and misery. There will be nothing left of the Jewish problem but the cemetery. The eventual savage suppression of the Warsaw Ghetto uprising and the deportation of some 300,000 to the death camps. In September 1935, however, all that lay in the future. The 45 Nazi lawyers who gathered on board the Europa under Fischer's leadership, including 38 men and 7 women, were traveling in style. As the Nazi legal press observed, the U.S. dollar, pummeled by New Deal monetary policies, was at an advantageously low exchange rate, and they could promise themselves a posh experience. The study trip was to begin in New York, where the delegation was to be feted at a reception organized by the New York City Bar Association. Thereafter, they were to enjoy an educational program offering special insight into the workings of American legal and economic life through study and lectures, as well as a broad overview of life in the New World in general. Members of the Nazi Accountants Association were also invited to participate, though there is no sign that any Nazi accountants joined the trip. Before they sailed, the 45 received a festive on-board greeting from the party legal bigwig Hans Frank, communicated to them by Wilhelm Heuber, chief of the Nazi Jurists Association. The greeting gave voice to what must have been a sense of triumph among Nazi lawyers in the aftermath of the Nuremberg Rally, with its elevation of the swastika and formal enactment of the party anti-Jewish program almost 3 years in the making. The participants were, in the jargon of the association, upholders of German law, and Heuber described their trip as the reward for a year of struggles on behalf of a new order that had prevailed over its opposition. As Dr. Heuber explained, through this study trip, the upholder of German law would gain the necessary compensation for an entire year of work opposing an outdated type of jurist, always inclined to ignore the realities of life. Even at the distance of 80 years, one can almost still hear the 45 Nazis murmuring their satisfaction over the victories of the year, raising their glasses and clicking their heels. Not all went smoothly on the trip, however. The 45 arrived in New York on September 26th. That was 2 months to the day after 1,000 anti-Nazi rioters had stormed the SS Bremen, the sister ship of the Europa on which they sailed, and 3 weeks after Manhattan magistrate Louis Brodsky had delivered his incendiary opinion declaring the swastika to be a black flag of piracy, and Nazism to be an atavistic throwback to pre-medieval, if not barbaric, social and political conditions. New York City was, in short, a hotbed of anti-Nazi sentiment, home to numerous Jewish elements, and the visitors met with protests. After they were spotted in their Garment District Hotel greeting each other with Heil Hitler and giving the Nazi salute, Jewish fur merchants organized a noisy demonstration against them that lasted a full 6 hours and required a substantial police presence. Fischer, the leader of the group, responded to this disturbance with memorable indignation. Jews, huffed Fischer, who was to be hanged for his war crimes in 1947, were treated in a kindly and dignified fashion in Nazi Germany. We came on a study trip to gain first-hand impressions of America, and our first impression is a bad one. The impression of the city of New York was tremendous, but the other impression was bad. I realize that decent-minded Americans do not approve of this demonstration and are very friendly and hospitable. What I saw of the demonstration was exclusively Jewish. Germany treats her guests well, and even Jewish guests are welcome. This summer there were several international conferences in Germany with Jewish participants, and they were treated in a kindly and dignified fashion. Once he was done venting his spleen, though, Fisher emphasized that the impression of New York City itself is powerful and overwhelming, and he added an expression of his especial satisfaction at the warm reception that the City Bar Association had given him and his fellow Nazis. Sadly, it does not seem possible to learn more about how Fisher and his group fared on their study trip, though the curious will find online a film of what is probably Fisher's hanging. But as we have seen, we can know a great deal about Nazi interest in American law during their previous year of work opposing an outdated type of jurist. There was plenty about America that Nazi lawyers of the early 1930s rejected, especially about the liberal America of Louis Brodsky, the Jewish fur merchants of New York, and those who agreed with them. But there was also plenty that Nazis found to like. Fisher was not the first Nazi lawyer to distinguish between Jews and decent-minded Americans. Hitler and Goering had done the same at the Nuremberg rally 11 days earlier, and Fisher's delegation was not the first Nazi group to study America, nor the first to take away a powerful impression. From Mein Kampf onward, Nazi jurists and policymakers took a sustained interest in American race law. Especially during the early 1930s, the era of the making of the Nuremberg Laws, Nazis engaged in detailed study of American immigration law, American second-class citizenship law, and American anti-miscegenation and mongrelization law. Some of them saw attractions in the system of Jim Crow segregation. In particular, the Prussian Memorandum, the 1933 text that laid out the basic statement of the radical Nazi legal program, specifically invoked Jim Crow, though it proposed a more limited version for Nazi Germany. Certain aspects of American race law struck Nazi observers as appealing. In particular, the exceptional American practice of harshly criminalizing interracial marriage lay in the background of the blood law. Other aspects, like the one-drop rule, struck them as excessively severe. Some of the more vicious Nazis, notably Roland Freisler, championed the lessons to be learned from American legislation and jurisprudence, while moderates like Justice Minister Gertner worked to downplay the usefulness of American precedents. Nobody argued in favor of a wholesale importation of American practices. Everybody was aware that America had liberal traditions that were at war with its racism, but many expressed their approval of what the National Socialist Handbook of Law and Legislation called America's fundamental recognition of the imperative of creating a legally enforced race order, though Nazi authors always added that the task of building a fully realized race state remained for National Socialist Germany to complete. What shall we say about all of this? It is important to begin by underlining what the history in this book does not tell us. It does not explain the genesis of Nazism. No sensible person would conclude that it was American inspiration that led causally to the crimes of the Nazis. It is lunacy to claim, as extremists on both the left and right have been known to do, that the United States is the source of all evil in the world, and it would be lunacy to hold the United States responsible for what happened in Germany and its dominions from 1933 to 1945. Nazism happened for countless reasons, most of them indigenous to Germany. The responsibility for Nazi crimes rests with Germans and their direct collaborators. In the end, the United States certainly played its part in the defeat of Hitler, and it has certainly been a force for good in the world often enough. What the history presented in this book demands that we confront are questions not about the genesis of Nazism, but about the character of America. The Nazis, let us all agree, would have committed monstrous crimes regardless of how intriguing and attractive they found American race law. But how did it come to pass that America produced law that seemed intriguing and attractive to Nazis? In some ways, that question is not hard to answer. We all know that there was racism in the United States and that it ran deep. It is not news that America had ugly race law in the early 20th century. We all already knew that there were parallels between Jim Crow America and Nazi Germany. After all, they are obviously there. We already knew about the Nazi interest in American eugenics. Historians have already documented Nazi admiration for American westward expansion. If the Nazi vogue for Franklin Roosevelt is not well known, it has nevertheless been identified already. If we were not aware of the depth of Nazi interest in American race law during the making of the Nuremberg Laws, we should not be entirely astonished by it. The image of America as seen through Nazi eyes in the early 1930s is not the image we cherish, but it is hardly unrecognizable. Nevertheless, seeing America through Nazi eyes does tell us things we did not know or had not fully reckoned with, things about the nature and dimensions of American racism, and things about the place of America in the larger world history of racism. Not least, seeing America through Nazi eyes tells us some uncomfortable things about the character of American legal culture. America's place in the global history of racism. First of all, seeing America through Nazi eyes brings home a truth that wise scholars have recognized, but that our general culture has so far been slow to grasp. The history of American racism is not just a history of the Jim Crow South. We must overcome the tendency to equate race law in America with the law of segregation. We must look beyond the mirror images of Nazi Germany and the southern states. If we think of the history of race in America as the history of Plessy v. Ferguson and Brown v. Board of Education, of segregation and the heroics of the Civil Rights Movement, we risk blinding ourselves to an immense expanse of what has taken place. European observers of the 1930s all recognized that black-white conflict was only one aspect of the history of American racism. Indeed, Nazis almost never mentioned the American treatment of blacks without also mentioning the American treatment of other groups, in particular Asians and Native Americans. To them, what Nordic America faced was not just the Negro problem, but the problems of Mongols, of Indians, of Filipinos, and of innumerable other non-Nordic groups trying to push their way in. By the same token, America's influential stature in 20th century world racism had to do with wider American campaigns and other American forms of law than just segregation in the South. In particular, it had to do with national and nationwide programs of race-based immigration, race-based second-class citizenship, and race-based anti-miscegenation law. Those were the aspects of American law that appealed most to Nazi Germany, not Jim Crow segregation in the narrow sense. And as we have seen, the appeal of those aspects of American law for the Nazis was strong. That is the unpleasant fact of the matter, and it forces us to confront an unpleasant historical datum about the place of America in the world history of racism. In the early 20th century, the United States was not just a country with racism, it was the leading racist jurisdiction, so much so that even Nazi Germany looked to America for inspiration. What David Fitzgerald and David Cook Martin conclude about immigration, that the United States was the leader in developing explicitly racist policies of nationality and immigration, is true of the other areas of the law this book has surveyed as well. In the early 20th century, the United States, with its deeply rooted white supremacy and its vibrant and innovative legal culture, was the country at the forefront of the creation of racist law. That is how the Nazis saw matters, and they were not the only ones. The same was true in Brazil, just as it was true in Australia and South Africa, just as it was true of the German colonial administrators who went hunting for a model for the making of anti-miscegenation law. And while the Nazis liked to mention South Africa as a fellow traveler, in practice they found very little South African law to cite in the early 1930s. Their overwhelming interest was in the classic example, the United States of America. To be sure, to say that the United States was the leader in racist lawmaking is not to say that it was the only country that can be accused of racism. It most certainly was not. Europe had its own centuries-old history of persecution, which manifestly prefigured much of Nazi policy. The Nazis of the early 1930s were not the first Europeans to seek to expel their Jews, as they were well aware. Moreover, there was race law of some kind to be found throughout the world of European colonial and imperial expansion. Iberia and Latin America had a tradition to which some historians trace the roots of modern race law, a tradition as old as the 16th century. By the end of the 19th century, there was explicitly race-based exclusionary immigration legislation in Brazil, and a figure like Johann von Leers, Nazi author of Blood and Race, A Tour Through the History of Peoples, was eager to argue that some measure of racist law could be found throughout the centuries. Most especially, there was plenty of racism among the other daughter nations of British imperialism. We must pay attention when a leading Nazi jurist like Otto Kohlreuter speaks of the interesting results to be found in the United States and the British dominions. Passages like that one suggest a haunting question about the Anglo-American common law world. The backdrop to Nazism is to be sought partly in British traditions. It is to be sought among the democracies of English-speaking free white men, not only in America but also in Australia, South Africa, and to a lesser extent elsewhere on the British globe. These were all places where yeoman settlers claimed rights of egalitarian self-government at the expense of disfavored and sometimes warred-upon minorities, and the Nazis looked with interest on all of them. But within that world, America was the leader during the age of the rise of Hitler. That is the truth, and we cannot squirm away from it. It was American immigration, citizenship, and anti-miscegenation law that the Nazis cited over and over again. It was American Jim Crow that was highlighted by the Prussian Memorandum. It was a memorandum on American law that the Justice Ministry prepared for discussion at the planning meeting of June 5, 1934. It was American law to which the radicals at that meeting turned. It was the American criminalization of racially mixed marriage that was the forerunner of the blood law. It was the American conquest of the West that Nazis invoked so often while engaged in the murderous campaigns of the 1940s, just as Hitler was already invoking it in the 1920s. Nazism was certainly not a product made in America and imported into Germany, but it remains the case that when the Nazis set out to build a racist order, they turned to America first to see what sort of models they could find. Of course, that sounds extremely strange today and even perverse. We think of America as the home of liberty and equality and as a stalwart in the Herculean Allied anti-Nazi struggles of World War II. More broadly, we think of British common law traditions as a prime historical source of the modern culture of rights, perhaps even as the prime historical source. But some of the strangeness dissipates once we understand the claims of Nazism. Nazism, too, was a movement for equality, if not for liberty. As I have argued elsewhere, the promise of the national revolution of Nazism to the general German population was a promise of leveling up, a promise that all racial Germans, as the Nazis defined them, would count as high-status members of German society. Society would no longer be divided into noble Germans and commoner Germans, master Germans and servant Germans. Now every German would count as a co-equal member of the ruling class by simple virtue of membership in the master race. The Nazi National Revolution was, in that sense, a thoroughly egalitarian social revolution. The resemblances to the Anglophone and especially American world were much less remote than we would suppose today. American white supremacy, too, was founded in a resolute egalitarianism among white men. It was a movement that affirmed the equality of every member of the favored race, while forcefully rejecting the status inequalities of the aristocratic past. Such was the nature of Jacksonian democracy in particular. In that sense, the connection between American egalitarianism and American racism ran deep. When Hitler praised America in Mein Kampf, it was partly because he believed that America permitted exactly the sort of leveling he believed Germany needed. America, unlike Europe, was producing a wealth of inventions because the Americans, unlike the Europeans, gave talented people from the lowest social orders the chance to make something of themselves. Hitler, too, promised to transform German society by bringing people from the lowest social orders up in the world. Of course, this egalitarian promise would be realized only at the expense of non-Aryans, but again, this was nothing different from what was to be found in vast stretches of the Anglophone world. In this connection, it is worth observing that the German words for master, Herr, and supremacy, Vorherrschaft or Oberherrschaft, are close cognates. The German master race is the near linguistic cousin of the English white supremacy, and German authors of the Nazi period understood it that way. So the Nazi interest in America in the 1930s is not quite as strange as it seems today. It is also, of course, essential to bear in mind the geopolitics of the age. The Nazis looked out on a globe that had been largely mastered by English-speaking countries. The British had aimed for world domination long before Hitler did. Moreover, Anglo-American leaders and intellectuals themselves, most prominent among them Teddy Roosevelt and James Bryce, explained and defended their control of so much of the earth with frankly racist arguments. These were men who believed, in the words of T.R., in keeping the temperate zones of the new and the newest worlds a heritage for the white people. And among the Nordic powers, America was the natural geopolitical model for Nazi Germany, as scholars have rightly noted. It was the Anglo-Saxon United States that had built an imposing continental empire, and that therefore stood out as an expansionist model for the Reich that was determined to conquer to its east. It was the Anglo-Saxon United States that had invented an international law doctrine that justified its place as a hegemon in its hemisphere in the form of the Monroe Doctrine and its more assertive Roosevelt corollary of 1904. To be sure, interwar German racists often speculated that the United States would succumb to race mixing and therefore decline, though Adolf Hitler himself thought differently, at least until the outbreak of World War II. But even if some of them thought America might falter, that was no reason for them to refuse to learn the lessons of American racism. The possibility of American geopolitical decline only brought home the truth that Nazi Germany would have to apply American policies with a rigor that Americans themselves had failed to sustain. But for all the attractions of Nordic America in Nazi Germany, is it not obvious that there remained significant and ultimately profound differences? Of course there were, as the Nazis themselves emphasized. First and foremost, American race law coexisted with a constitutional tradition that had a strong grip on American legal culture, especially in the form of the Reconstruction Amendments. To be sure, that grip was not strong enough to prevent the United States from pioneering in the creation of racist institutions. American legal history of the decades after 1877 is a largely unrelieved record of shameful evasion of the principle of equality that the Reconstruction Amendments were supposed to enshrine. The principle, as the Nazis contemptuously put it, that everyone who bears a human countenance is equal. Nevertheless, the Reconstruction amendments were there, and American lawyers always had to reckon with them, if only in devising evasions. As Desmond King and Roger Smith have written, there was always a tension between two racial orders in America, a white supremacist order and an egalitarian transformative order. There was certainly nothing comparable in Nazi Germany, and Nazi observers looked on the American constitutional tradition with a mixture of bemusement and disdain. Nor was it only the constitutional tradition that set America apart from Nazi Germany. There was also another, arguably even more important difference as well. Nazi racists made a very different and far more merciless use of state power than American racists did. On this subject, it is useful to turn to Gunnar Myrdal, the Swedish social scientist whose 1944 book, An American Dilemma, The Negro Problem and Modern Democracy, did so much to shake up American race relations and set the stage for the civil rights movement after World War II. Here's how Myrdal answered the question, commonplace in the 1930s and 1940s, of whether the Jim Crow South should be characterized as fascist. Is the South fascist? On account of the one-party system and the precarious state of civil liberties, the South is sometimes referred to as fascist. This is, however, wrong. The South entirely lacks the centralized organization of a fascist state. Southern politics is, on the contrary, decentralized and often even chaotic. The Democratic Party is the very opposite of a state party in a modern fascist sense. It has no conscious political ideology, no tight regional or state organization, and no centralized and efficient bureaucracy. The regimentation which keeps the South politically solid is not an organization for anything, least of all for a general policy. It is a regimentation against the Negro. The South is static and defensive, not dynamic and aggressive. There are things to object to in this analysis. Arguably, the Southern Democratic Party did have a general policy in the early 1930s, when, as Katznelson argues, it provided critical political support for the New Deal, and especially for anti-poverty government programs for its impoverished region. And the Nazi variant of fascism certainly was very much directed against Jews, not just for some positive vision. The resemblance between the United States and Nazi Germany in the early 1930s is closer than Myrdal allows. Still, at the end of the day, Myrdal put his finger on what is arguably the single most important difference between the racism in the Nazi mode and racism among their tribally related Americans. There was American and, more broadly, Anglophone racism in the background to the Nazi movement, but the Nazis brought something different: the organization of a fascist state. It is indeed the case that America was and is decentralized and chaotic by contrast with what emerged in the Central Europe of Hitler. America did indeed, and does, lack a centralized and efficient bureaucracy. The contrast emerges repeatedly in this book. We have seen how the Nuremberg Laws were intended to institute official state persecution in order to displace street-level lynchings. The United States, by contrast, remained faithful to lynch justice. Indeed, the number of lynchings rose noticeably during the period 1933 to 1935. We have seen that the United States, in its immigration and citizenship law, held back from open state-decreed racism, trusting instead in the legal subterfuges and covert devices necessary to preserve the facade of compliance with the 14th Amendment. The Nazis, by contrast, decreed their racism openly. The Nazis saw a great deal to like in America's fundamental recognition of the necessity of a race-based order, but they set out to make the creation of their own race-based order the business of an efficient state apparatus of a kind Americans have always refused to tolerate. So the differences were there, and they were real. Nobody should conclude that Nazism was some sort of mechanical transplantation of American racism into the soil of Central Europe. But the similarities were there too, and we cannot wish them away. There were reasons why Nazi observers could arrive at appalling judgments such as that our founding had created the strongest prop in the struggle of the Aryans for world domination. There were reasons why the National Socialist Monthly could write so warmly in November 1933 that to tribally related Americans we reach out our hand in friendship. White supremacy did indeed have a storied history in America, as a matter of legal history dating back at least to 1691, when Virginia adopted America's first race-based anti-miscegenation statute, and to 1790, when the first Congress chose to open naturalization to any alien being a free white person. In the early years of the 1930s, moreover, American white supremacy stood at one of its high watermarks, as the early New Deal did its work in political dependence on the Democratic Party that ruled in the South. When we add it all up, the right conclusion is this: American white supremacy, and to some extent Anglophone white supremacy more broadly, provided, to our collective shame, some of the working materials for the Nazism of the 1930s. In that sense, the history of Nazism cannot be fully told without a chapter on the interesting results that Otto Kohlreuter identified in the United States and the British dominions. But in Nazi Germany, supremacist traditions and practices acquired the backing of a state apparatus far more powerful than anything to be found in the world of the daughters of British imperialism, and far more ruthless than any that had ever existed in Europe west of the Elbe.